Welcome to the um, afternoon session of the conference. I have the pleasure of welcoming um, back Sam Bagg and welcoming Elizabeth as well um, to RGCS. Sam Bagg is a former um, postdoctoral fellow here at RGCS and currently a fellow in politics at Nuffield College, Oxford, working on his book, The Dispersion of Power, A Critical Realist Theory of Democracy. And Elizabeth Beaumont, why don't I see your bio here? Well, Elizabeth Beaumont, from what I read before, is a professor at UCSC of political science as well, and has been a long time friend of RGCS. She's also the author of the Civic Constitution. So without further ado, I will turn over the floor to Sam, who I think is the first one in the order of the panels.
Yeah, great. And I'm going to do something apparently blasphemous at this conference. I'm going to share my screen for a PowerPoint, if that's all right. All right. So thanks to everyone for being here. I'm very glad to be able to come back and talk to the RGCS, even if it's virtual. The paper I'm presenting today comes out of my book, as Victor just said, where I argue that it's better to see democracy as a way of resisting state capture rather than achieving collective self-rule. And I workshopped an earlier version of this manuscript, the book manuscript, at McGill when I was a postdoc there. And one of the things that I took away from that workshop was that the book needed a better transition from the first half, where I give my reasons for being critical of collective self-rule, to the second half, where I spelled out the practical political implications of the alternative approach that I was suggesting. And in particular, it needed a more systematic account of both state capture itself and the ideal of resisting state capture that comes out of it. And I ended up writing 2 new chapters in response to that kind of feedback. And so when Jacob asked around about potential contributions to the conference, I was very eager to jump at the chance to present one of these new chapters, the one where I'm trying to give a general picture of the political orientation that's implied by this ideal of resisting state capture. And yeah, I mean, so I realized that for those who don't know the broader project, it might seem to come out of left field because I won't have much time today to give background or motivation. I also won't have time to give a lot of detail about the practical implications that follow from the framework. This is really a transitional chapter presenting a really general framework in pretty abstract terms. And so to some extent, I'll just have to ask you to kind of give me the benefit of the doubt in terms of what comes on either side, background. But that said, I think there are 2 things about the chapter that should stand on their own and be of interest in themselves. And so I'll try to highlight those in the talk. First, my hope is that there is intrinsic interest in the political orientation itself, not because any one of its component parts, which we'll see is totally novel, never heard of before, but because it justifies and combines these parts in a way that I think is rather unique. And then second, in the context of this conference more specifically, the paper makes some perhaps provocative claims about the continuity of liberal constitutionalism with a range of more radical principles and practices. Okay, so just to get a few definitions on the table to start. I define state capture, central concept, as the use of public power to further the ends of private actors or partial factions at the expense of the public interest. The most obvious examples of this are things like tyranny, authoritarianism, oligarchy, corruption, clientelism, regulatory capture. But the definition also makes, it also includes these more decentralized, society-wide, potentially unintentional even forms of domination and oppression, systems like patriarchy, white supremacy, and so on, to the extent that they are anchored in or reinforced by the use of state power, which, spoiler alert, they usually are. Okay, so this definition of capture relies on a normative concept of the public interest. But the ideal of democracy as resisting capture is not just equivalent to the achievement of public interest, and it's important to clarify that, right? Democracy instead refers to the social, economic, and political structures which constrain public actors, which help to ensure that public power serves public interest. So it's not just the achievement of the public interest in a direct way. And my aim in the chapter of this book is to give an account of how to do that, right? How to resist capture of the state in the broadest possible terms. And I ultimately settle on 6 key principles. 3 are fairly traditional liberal principles, right? Constitutionalism, competition, universalism. And 3 then are a bit actually more radical, right? So anti-monopoly, countervailing power, and systemic redistribution. And to some extent, all these principles are familiar. But as I said, part of the interest here lies in the somewhat unorthodox ways that I'm sort of justifying and combining them. And in this context, more specifically, part of the interest lies in the claim that constitutionalism must be integrated with more radical strategies in order to effectively achieve its own kind of true goals, its own true potential. And I start with constitutionalism. It makes a lot of sense to start with constitutionalism because something like resisting state capture is already central to the way that we think about what it's good for, right? It's already about resisting tyranny, arbitrary power, and so on. And this involves first order constraints, which are designed to prevent specific abuses of power. But I think the real heart of constitutionalism lies in what you might think of as second order constraints, which are aimed at trying to prevent anyone from accumulating too much concentrated political power in the first place, on the grounds that they could then use that power to circumvent whatever first order constraints we want to be enforced about, limits on abuses, right? So in that sense, a central question of constitutionalism is how do you structure public power in such a way that no one in particular can capture it and use it for advancing their own interests. And in this, of course, certain formal political structures can help. But as we've seen, I think over the past few days, this goal also requires a number of informal background conditions and other supporting practices. So for instance, separation of powers, often held up as an important pillar of constitutionalism, a way of preventing tyrannical power and abuse, centralization of power. But if the people that are occupying different offices within the state, in different branches or what have you, if they all belong to the same partisan faction, separating them in this formal sense, that doesn't actually do very much. What really matters, it seems, is having competing factions that are distributed throughout the state, who have both sufficient power and sufficient incentive to put up a fight when it comes time to do that. Or in the words of one influential paper on this topic, you need separation of parties, not just separation of powers. And in fact, the importance of competition goes far beyond just that of competition between political parties, which is suggested by that phrasing, right? So if you think about the work of our hosts, Jacob and Victor, right, they're insisting on the value of pluralistic competition between voluntary associations, religious groups, civil society organizations, and so on. And as they sort of eloquently point out, this is also very important for sustaining democratic life. And then, of course, there's market competition. Regardless of the effects of markets on efficiency, for me, it seems markets are perhaps even more important for their unpredictable effects on the distribution of power, which is not, markets don't always have those effects, but they can in a very, and that effect is very powerful. So basically, in economies that are built on more fixed, stable sources of income, landowning, resource extraction, things like that, it turns out to be very easy for the members of a ruling coalition to kind of appropriate the vast majority of the economic rents and distribute them in ways that help them to entrench their own power and cement the ruling coalition, right? And that is just much harder to do in a more open and dynamic economy with more market competition, where the results of of economic transactions are harder to predict. So this by no means means that competition is always good. I mean, for one, violent competition is usually very bad, right? It tends to end with one side, the victors, nothing against you, Victor, but the victors possessing absolute control. And then, of course, more broadly, political, religious, economic competition, the kinds of competition I've discussed as potentially good, they also have, even when they remain peaceful, they have plenty of pathologies in themselves. And it's at least partly then in order to counteract some of these pathological tendencies that we need these other four principles, right? In my view, all of these other principles, universal anti-monopoly, countervailing power, systemic redistribution, all of them can be seen as ways of keeping competition in line, of making sure that it remains a democratizing force. So to put it another way, political, social, economic competition is necessary to fulfill the promise of constitutionalism, to prevent dangerous concentrations of political power. Meanwhile, the other four principles are all necessary for making sure that competition actually serves this democratic. Perhaps the most obvious step to take, I think, in this context is to make sure that the relevant kinds of competition are formally accessible to everyone rather than just a limited elite. And that is essentially how I understand the value of universalist practices like the rule of law, civil and human rights, universal suffrage, social insurance schemes, and even something like public deliberation. And, these are pretty basic ideas. They're part of the standard democratic package, but it's worth saying, on my account, their value is not grounded in any particular foundational view of human agency or equality. And that's a key difference, right? Instead, their value lies in how they obstruct public officials from abusing their power. So, for instance, the easiest case to see, I think, is perhaps universal suffrage, right? Universal suffrage, or maybe it's not the easiest to see, but it's the one I've thought the most about. So universal suffrage is not important, I think, because everyone is equally competent or equally deserving of exerting political power over others, right? That's a pretty solemn responsibility. But what it's good for instead is to prevent anyone from entrenching their power by manipulating the criteria for enfranchisement. That's what I see as the sort of most basic, sort of uncontestable grounds for universal suffrage. And something similar, I think, can be said about a lot of the other universalist rights and guarantees. Nevertheless, despite this sort of difference in the nature of the justification that I'm giving for these things, so far I've basically just offered a redescription of liberal democracy, and maybe that's of interest, but it may be of limited interest. And that's where these other three principles come in, right? Again, none of these are completely original to me, but what may be more distinctive, I think, is the way that I see them as necessarily intertwined, both with one another when sometimes they're seen to conflict, and also with, of course, the liberal principles that I've just discussed. So, okay. The reason is that there are still many ways, I think, in which liberal democracies still favor certain factions. And I think, we might have different views about which factions, but most of us can accept that. In my view, the most pressing, dire problem in most liberal democracies is that we call oligarchy, right? The way states protect the interests of wealthy elites. And so, in exploring the three radical principles and what they mean in practice, in the next couple of minutes, I'm going to take for granted that as my example of a key problem we have to deal with. But there are other factions and elites that also have outsized control over public power. So if you don't like that particular example, you can also apply these principles to, whichever elite or faction that you think is most dangerous and most in need of checking. So some radicals and Democrats believe that the solution to this kind of problem that I'm talking about, oligarchy and so on, is more collaborative participation in political institutions, whether it's direct democracy, deliberative panels, citizens' assemblies, some form of constituent power, at the limit, collective ownership of the means of production, something like that. And some of these strategies can have value in certain contexts. I don't mean to dismiss them, but for me, they're not always the most promising because they're targeted at the wrong kind of problem, right? The problem is not that we are competing too much, right? that we're not listening to each other, that we're not collaborating enough. No. For me, the problem is that certain factions and elites have extremely outsized power. And so the terms of the competition that we are always already engaged in is those terms are profoundly skewed, right? So what we need then is not less competition, but more competition, or at least more egalitarian competition. And that is what these three radical principles are ultimately about. Instead of encouraging more collaborative participation in neutral political institutions, the idea is to level the playing field across social and economic realms, to disperse private power. More specifically, the three strategies are, first, to constrain the most powerful private actors, second, to support the least powerful actors, and then third, to flatten the distribution of private power in a more general fashion. So first, the term anti-monopoly comes from a progressive era tradition that emphasized taking on the outsized power of wealth through things like very aggressive antitrust policy, breaking up big corporations, and so on. And it's enjoying a resurgence today in, perhaps unsurprisingly, what we call the second Gilded Age, even more surprisingly in the Biden administration. But in any case, the general idea of anti-monopoly is much bigger than just that sort of antitrust idea. It refers to all sorts of ways that we might apply increased scrutiny and constraints to actors with extremely concentrated private power, the kind of actors that are most likely to play a distorting role in political economy and society more broadly. I don't think we need to go quite as far as the Athenian tradition of ostracism, but that's sort of the general idea, right? In the present context, we're talking more about wealth taxes, capital controls, banking transparency, citizen oversight juries, things like that. I can't see the chat. Victor, can you just signal to me how many minutes? 2 minutes? Okay, perfect. Okay, so countervailing power draws on then another strand of radical thinking, which is sometimes seen as being in some tension with the anti-monopoly tradition, because it involves not breaking down power, but actually building up concentrated power in the form of things like strong labor unions, community organizations, social movements, and so on. But really, I think both of these traditions are ultimately tackling the same problem, right? Problem of oligarchy, and neither one is sufficient on its own. Some problems aren't susceptible to one sort of solution, and you need to be firing on all cylinders, right? Given that wealthy elites have such extraordinarily concentrated power, you need concentrated power on the other side. You need powerful, durable, disciplined organizations that reliably represent the interests of ordinary people. And this is where I think it's important to have things like collaboration and solidarity, and in some cases, even widespread participation, right? The difference is that it's not in service of this fictive ideal of a consensual society beyond political conflict, but instead it's in service of a explicitly partial oppositional form of power, which is required to balance the power of wealth. Okay, the last major principle, systemic redistribution, it's even simpler, right? Where power resources are unevenly distributed, the goal is to flatten the distribution, not to make it completely flat, but for me at least, the goal is to make it much less skewed than it is, I think, anywhere in the world at present. And the baseline assumption that is motivating all these strategies is that those with concentrated private power are predictably going to use it to turn public power to their advantage, right? And on the other hand, no safeguards will ever be fully successful in preventing inequalities in social and economic realms from spilling over into politics. So the only way to reliably resist capture by those with concentrated private power is to take their power away fundamentally, right? Or at least to substantially reduce the scale of their advantages. And that's the goal of all three of these radical strategies. And just to bring it back to the themes of this conference, I think this sort of insight is actually very much at home in the discourse on constitutionalism, right? If you don't trust parchment barriers to constrain tyrants, if there also needs to be these supporting practices and background conditions to make good on those formal guarantees, you also can't rely solely on the formal guarantees of liberal universalism. A free society, a democratic society, a society that resists the capture of the state, that kind of society surely requires the kind of limits on discretionary state power that you have from constitutionalism. But in order to fulfill that promise, political constitutionalism must be supplemented by a range of practices and institutions. And that includes the ones that pretty much everybody acknowledges: active competition across political social realms, the competition that's open to all. But in addition, I've argued that it requires far more active and radical efforts to level the playing field. Okay, so that's basically the argument. I haven't really scratched the surface even of what this might look like in practice, and it's also worth saying I've highlighted the ways these principles are intertwined, the way they support one another, but they are also certainly going to come into conflict at times. So there's always going to be sort of hard judgments to make in any given case about what to prioritize. That's what the rest of the book is about. But what I hope you take away from this talk today is a sense that this somewhat unorthodox collection of principles is in fact a coherent political orientation. And that this orientation plausibly captures both what we like about existing constitutional democracies and what desperately needs to be reformed about them. Okay, so I'll stop there. Thank you.
Great. Thank you. So we turn to Elizabeth, and I wanted to add, she is not only a professor of politics, as I said, but also director of legal studies. I was working off an outdated program, but everything else that I said about Elizabeth is true. So I turn over the floor to you.
Thank you so much. It's really a pleasure to be here. And thank you so much to Jacob and Victor and all the organizers and all of my fellow participants. I've really been learning a lot from so many of the panels, and I wish we could be there in person, but this is kind of the next best thing. So Sam had ended his talk saying he wasn't quite sure what his ideas of countervailing power were going to look like in practice. And so maybe my paper and my talk can help to provide some possible ideas for that. So my paper is titled "The Promise and Perils of Popular Constitutionalism for Constitutional Democracy." And obviously, there's a sort of a looming question over this conference and over this era where we have rising authoritarianism, democratic backsliding, demagogic populism. And we could think of one version of this question as being, does popular constitutionalism help to strengthen constitutional democracy, or does it overload it, threaten it, abuse it, or capture it? And of course, this is a very complex issue. It affects many countries, as we've already glimpsed from some of the other panels. And my paper is thinking of this sort of controversial role of popular constitutionalism by focusing on the US. This is certainly inadequate for thinking about constitutionalism around the world, but I actually think the US case can be really helpful for cross-national consideration, because the US is a place where we see a very wide range of examples of popular constitutionalism operating in different eras over a pretty long time period. So from the mid-1700s and the present, we see kind of a various range of kind of ideologies that have been attached to it, actions and outcomes, including sort of, if we go back to the early 18th century, we see that it played a very crucial role in forming what began as the modern constitutional republic of the US. And then, of course, it's played a role in both pursuing and blocking the expansion of that republic into a multiracial and inclusive democracy. And it continues to play a very fraught role in our current political landscape. So I'm just going to try to quickly summarize the basic argument of the paper and highlight some of the ways that I'm developing it in relationship to the US examples. And then I want to close by pointing to some examples beyond the US and hope that that will open up the conversation to themes and topics that have come up among some of the other panelists. So the problem of popular constitutionalism is embedded in the ongoing challenge of what we can think of as the dual and dueling commitments of democratic constitutionalism. The commitment to democracy on one side, which is a commitment to free and equal citizenship, to citizens' participation and self-rule, a system of governments purportedly created by, for, and of we the people that is often indicated in modern constitutions. And then on the other side, a commitment to constitutionalism, a commitment to rule of fundamental law as enabling and limiting governmental power, including through things like fundamental rights. So upholding these two dueling commitments involves trying to maintain a healthy dynamic between them, which is very difficult. We can't allow one to overtake the other. And achieving that, of course, is sort of the ongoing challenge, the ongoing work of being a constitutional democracy. But this question of the balance and how to prevent imbalance is especially fraught now. And it's interesting that even as we finally have begun to see a lot of growing scholarly interest in the role of political activism and civic groups and social movements and what we would call popular constitutionalism in recent decades, in this moment, there's very serious, very growing concern that populist ideologies and mobilizations are threatening to destroy constitutional democracy itself. So we see very heated debates. There are those who think that popular engagement with projects of constitutional democracy are really valuable, if not necessary, if we want to have a constitutional democracy. And there are those who really fear it and criticize it and think that the success, the continuation of this project depends instead on the capacities of elites and institutions to safeguard constitutional democracy from the popular passions that might overrun it. So in the last session, Mila had said that, sort of, it's hard to be in favor of populism, maybe at this moment in time, or maybe among those of this conference. And certainly a lot of my past work has been in favor of certain forms of popular constitutionalism. And here I'm offering maybe a more ambivalent view than I have in some of my earlier work. So I am wanting to contribute to this debate by staking out an argument for understanding popular constitutionalism as a very broad umbrella concept, a broad political phenomenon. And although this might seem to be very straightforward, it's actually difficult because it involves challenging a lot of the misperceptions that were created by the earliest scholarship that began to emerge under the kind of framework or under the term popular constitutionalism. So to kind of stake the claim for this, I draw attention to a range of different manifestations, positive and negative, that have shaped the American past and present. And my argument is sort of just boiling down to this. Once we see the tremendous breadth and variability of these manifestations of popular constitutionalism, or once we recognize its multivalence, we realize that there cannot be a single answer to the question of whether popular constitutionalism strengthens or harms constitutional democracy. It all depends. It's a sword that can cut both ways. Some of the manifestations that have emerged in the US and the effects that they've had show us that the worst forms of popular constitutionalism are really deeply perilous for a project of constitutional democracy. This has been the ideas, the actions of popular constitutionalism have been taken up by groups like the KKK in the 1860s, by white militias, such as the Oath Keepers today. And when we see these forms of popular constitutionalism, we see that it corrodes both the constitutional and the democratic side of constitutional democracy, because it demands constitutional meanings and regimes that are exclusionary and repressive. It acts as law unto themselves. It enables autocrats to abuse and entrench their own power, often through constitutional change. So therein lies the peril of the peril and promise. At the same time, we can't leave it at that, because at its best, there are manifestations of popular constitutionalism that have played and continue to play a really vital role in articulating and pushing forward what I would argue are the greatest promises of constitutional democracy. So these beneficial forms have involved crucial work from groups and movements such as abolitionists, suffragists, civil rights movements, union and labor movements, LGBT movements, and others. And they've engaged in forms of popular constitutionalism that have sought to expand the inclusiveness of membership in constitutional democracy, expand suffrage, to articulate and implement fundamental human rights that would not have been adopted into many constitutions without the efforts of these groups, and to define the modern scope and limits of constitutional powers, as well as identifying forms of corruption and abuses of power and derelictions of duty to uphold constitutional guarantees. So my argument is that when you see popular constitutionalism operating in this way, it can make profound and sometimes transformative contributions to the constitutional side of constitutional democracy, as well as the democratic side. And I think this hasn't really been noted even by those who are generally supportive of the idea of popular constitutionalism, that those who favor it tend to see it as always beneficial to the extent that it supports the democratic side, but I'm arguing that it can also support the constitutional side. So actually in the US, I would go so far as to say that we couldn't even claim that we are trying to be a constitutional democracy today without the ideas and influences that waves of activists, civic groups, social movements who've engaged in popular constitutionalism as part of their projects. I wouldn't say that their projects should be entirely understood through that framework, but as part of those projects, they became the first to envision and demand and struggle for inclusive multiracial democracy and broader understandings and more stringent implementations of constitutional guarantees of equality, of rights, of freedom, of justice. So just a brief summary of how I'm developing these arguments and some highlights of examples. So in trying to clarify the concept of popular constitutionalism, as I said, I think it's pretty, first of all, it's still not widely known, I guess sort of among some groups of constitutional scholars, the idea is familiar, but it's even among them, it's often misunderstood. So my working definition thus far is popular constitutionalism is a distinctive mode of politics, a mode through which members of the people or civic actors assert their constitutional views and claims into constitutional debates and politics. This mode of politics includes the forms of ideas, discourse, and nonviolent political action through which civic actors invoke foundational political principles or specific constitutional claims and goals. And in doing so, they assert a role in shaping the meaning and implementation of the Constitution. So on this view, the popular component of popular constitutionalism is not the equivalent of populist. It is simply a reference to the broad idea that those who are engaging in this identify themselves as members of the people or members of the civic body rather than officials or part of the elite governing body. The constitutional component of popular constitutionalism refers to the idea that people are asserting claims about and attempting to influence the interpretation and implementation of fundamental principles and supreme law. So these are things like the meaning and scope of basic liberties and rights, the definitions and allocation of citizenship, the legitimate uses and limits of institutional power, and so on. And this is what differentiates it from kind of just standard, kind of more generic political action. Now, as I said, unfortunately, we would say the kind of historical scholarship on constitutionalism has almost completely left out the role of civic actors. And then once the idea of popular constitutionalism began to come on the scene in the 1990s, it was introduced with a relatively narrow set of examples and a relatively narrow set of conceptions that created, I think, some enduring misperceptions. So these include the following. First, the idea that popular constitutionalism is indistinguishable from populism or that it's prone to radical populism. Second, and somewhat relatedly, that popular constitutionalism is inherently anti-court or more generally anti-institutional. And third, and I will confess that some of my work has contributed to this perception, that popular constitutionalism is inherently progressive or democracy enhancing. So as I noted, when we consider the range of different examples of popular constitutionalism in the US and elsewhere, we have all of challenges to all of these misperceptions. It isn't necessarily populist, it isn't necessarily progressive, it isn't necessarily anti-court or anti-institution, even though it does include all of these variants. What it does always involve are efforts to influence constitutional meanings, politics, decisions, sometimes by offering new definitions of rights, sometimes by demanding new institutional powers or constraints, sometimes by calling for broad constitutional transformations. But it doesn't always, or even typically, try to take the Constitution away from courts. It doesn't always demand direct forms of democracy. It doesn't always involve efforts to reject the interpretive roles or power of courts or other branches of government. In fact, sometimes it's trying to buttress one or more of these institutions against others. So this expansive conception, which I think is both more useful and more honest than the narrower and more specific conceptions that often have been more influential, it recognizes popular constitutionalism as a big umbrella, one that encompasses a lot of political ideologies and forms of action, some of which assist constitutional democracy, others that harm it. This includes forms of civic action that sometimes get referred to as politics out of doors, or the politics of protest and demonstration, and those kinds of more direct actions. But it always also includes a lot of civic action that involves engaging with and kind of participating in the work of political institutions in their existing forms, litigating, lobbying, petitioning, campaigning, and so on. It also involves forms of civic action that are more directed towards swaying fellow citizens and shifting public culture. So speeches, sermons, formation of civic groups, other kinds of kind of creative civic action would be included here. So while I'm rejecting the idea that popular constitutionalism is simply populism, I also think it's important to reject the argument that some have made, such as Bojan Bugarek, that populist constitutionalism can be fully differentiated or neatly isolated or partitioned off from popular constitutionalism. So Bugarek insists that popular constitutionalism always, quote, seeks to preserve the primary role of people in interpretation and administration of constitutional law and is compatible with liberal democracy. I think that or I disagree that this is true of all forms of popular constitutionalism, although I certainly think that there are some forms that fit that view. It's a broad, kind of multivalent phenomenon. It includes problematic types of populist constitutionalism as well as more beneficial variants. So let me just offer a few quick examples from the US. One thing to note is just how long it's been operating. So we see it in the ideas and activities of the early patriot groups that eventually turned into revolutionaries, including the sort of original Boston Tea Party, as well as what has become the more modern Tea Party. So that just kind of shows both the scope and maybe to some extent what we might think of as kind of the path dependency that got created by early popular constitutionalists, paving the way for future groups to take on that mantle. We see that popular constitutionalism shaped the initial expectations or scope conditions that surrounded the creation and adoption of the first US state constitutions and the national constitution, that it was operating in the demands to open constitutional ratification processes to include representation of more common men. It was involved in demanding amendments to the first US Constitution, which of course did not initially have any Bill of Rights. And to an important extent, we would say that these early forms of popular constitutionalism were a force that shaped the institutions of American constitutionalism, as well as the culture surrounding it, both of which contributed to or sort of paved the way for other newer manifestations of popular constitutionalism by other groups. So popular constitutionalism doesn't die out once we sort of get the new constitutional structures in place in the US. Instead, it starts to develop new branches and offshoots. So these include groups like Black and white abolitionists and civil rights groups from the 18th century who were litigating, they were convening and forming groups, they were petitioning, they were sermonizing, they were boycotting, they were fundraising, they were appealing to leaders and institutions, they were engaging in civil disobedience, and some did kind of take their popular constitutionalism and crossed over into the line of armed uprisings as well, to advance their belief that the US Constitution should or must be interpreted as an anti-slavery document and a charter of equality, one that would recognize the citizenship, suffrage, and equal rights of African Americans. And in fact, if we look from the 18th century forward, it appears that many, if not most, of both the progressive social movements for change in the US and their backlash or retrogressive reactionary movements have engaged in some forms of popular constitutionalism. Now, this may be out of inclination or it may be out of necessity, because pursuing significant changes in a constitutional democracy nearly always involves the work of first challenging the dominant constitutional meanings and laws. In a prior panel, Vertica mentioned the idea that populism is endemic to democracies. And so I guess I'm arguing that popular constitutionalism to some extent is endemic to constitutional democracies due to these dual commitments of democracy and constitutionalism, but also due to the institutional structures and processes involved in constitutional democracies. In many of them, it's very difficult to achieve transformation in constitutional fundamentals or basics or fundamental rights unless you go the route of popular constitutionalism. So jumping forward, we can see how popular constitutionalism was part of both sides of the same-sex marriage debate in the US. So you see how these tools get picked up and used on different sides of the debate. Each side tries to entrench their constitutional views through battles over legislation, through court decisions, and so on. And of course, in the US, only after a tremendous amount of work by these civil rights activists was the idea of marriage equality able to win out over the argument of in favor of maintaining exclusion. And of course, as I alluded to earlier, and this is where some of my more recent work has gone, we see veins of popular constitutionalism operating in groups like the KKK, the OG white supremacists who claim to be protecting the original US Constitution by terrorizing African Americans and their political opponents after the Civil War, and who in the 1920s also became civic activists who supported white supremacy as part of the constitutional system by lobbying for immigration laws that restricted non-European immigrants, which, by the way, the KKK did have chapters in Canada, as well as some other countries. So it is not a uniquely, even the specific KKK isn't unique to the US. Now, of course, we see that popular constitutionalism has been taken up by modern white nationalists and militia groups, such as the Oath Keepers, who were Trump enablers and staunch supporters and contributed to the violent July 6th insurrection that attempted to disrupt the constitutional role of the Senate and overturn the results of a democratic election. So these have been the darkest and most destructive examples of popular constitutionalism that the US has experienced in recent years and arguably since the Civil War. And of course, each country is distinct, but we can see counterparts of this type of problematic, populist, chauvinistic popular constitutionalism relating to or connected to movements elsewhere. So we can see these as movements that have helped to create and support political parties and leaders with aligned constitutional views, from Generation Identity, the movement that has helped to propel forward the National Front in France, to the origins of Fidesz, which started as an underground student activist movement that was opposed to the ruling Communist Party. So there are many more examples of popular constitutionalism in the US and from around the world. In the paper, I mentioned some from the last few years that suggest the more valuable forms of popular constitutionalism that are supporting both the democratic and the constitutional side of constitutional democracy. So I'll just mention one of those is Algeria's so-called Revolution of Smiles of the Hirak movement, which toppled the longtime president Bouteflika to prevent him from seeking an unconstitutional fifth term. And then I also, I should have mentioned, but I didn't, but the panel that on constitutionalism in Latin America gave another excellent example. And I forget which speaker, if it was Claudia or maybe Marcela and Sergio, or maybe Javier. One of the speakers mentioned the example of the 2019 popular constitutional protests in Chile. So these protests are those in which we have workers, students, feminists, indigenous people, the poor, who weren't just contesting social and economic inequality, which of course is very important, but they were also calling for an end to the Pinochet era constitution. They were trying to force the government to concede to holding a referendum to write a new constitution, a more democratic constitution, one that would undo the legacies of Pinochet's dictatorship and be more representative of all the people. So with that, I will close by encouraging the idea that each instance of popular constitutionalism needs to be judged on its own merits in a nuanced and informed way. It needs to be judged in terms of its ideology, its membership, its actions, its goals and outcomes, rather than adopting any blanket assessment that popular constitutionalism is either inherently harmful or helpful to constitutional democracy. That being said, I do think that harmful forms of popular constitutionalism are deeply problematic and that constitutional scholars need to be engaged in thinking about how to counteract or respond to them, but how to do so without undermining the capacity for beneficial forms of popular constitutionalism. As I said, I hope this paper can open a broader cross-national conversation. I hope it can also be in dialogue with many of the prior panels, which have been so interesting in bringing up concepts of the people, concepts of popular sovereignty, constituent power, constituent assemblies. Sam's paper, of course, on the idea of state capture and countervailing powers. Kind of so much here, I hope to bring into conversation. So thank you.
Thank you very much. I'll try to keep my comments fairly brief. I might have to skip over a few of them, but I found the papers wonderful, especially in the way in which they spoke to each other. They both are concerned with the problem of capture in some way. That is, with the problem of control over either the resources of the state or the agenda of the state by some kind of center, some kind of elite, whether it's an elite that attempts to capture the state for its own private ends, as Sam Bagg presents it, or an elite that has effectively controlled the agenda and the direction of constitutional interpretation, and which different popular movements are trying to upset or dislodge in some way. So both papers, in a way, define themselves as negations. There is a thesis by negation in both cases. In the first, because democracy in Bagg's paper is defined as non-capture, and in the second, because popular constitutionalism is not identified with the people as such. That is, it's not populism in that sense. It's defined as a constitutional movement, whether of interpretation, amendment, creation, upset, that comes from outside of the elite. That is what seems to define it as popular. If we cannot attribute that popularity to the people as a whole. Now, Bagg identified the 6 principles, the 3 liberal and the 3 radical principles, so I won't reprise them here. I do want to note, however, that one natural direction in which one's mind might go when encountering both the thesis and these principles is the Republican direction, to claim that there is some kind of argument about non-domination present in the paper. And although, as I recall, Bagg does discuss that elsewhere in the book project, in this paper in particular, the words domination and republicanism appear each once in the text, and in neither case in a strong normative sense. In fact, republicanism only appears in the title of an entry in the bibliography. Why not? Is this not a theory of non-domination? Well, not exactly. The normative notion that operates in the paper, the standard that operates in the paper, is not that of freedom as non-domination. It's rather the public interest. That is, a notion of the public interest which is left rather vague. In fact, in Bagg's own words, the public interest is whatever it happens to be. And it's defined mainly, again, by negation, in opposition to the private interest, not in light of a notion of freedom. Now, Bagg knows that I'm terribly sympathetic to this position. The more minimal we can have a conception of democracy, the more I like it. I do think it's absolutely central to both a liberal, a pluralist conception, but all of the normative weight that is put on the term I find problematic. However, here I have to push back a little bit. Now, whenever I hear the word perfectionism, I reach for my gun, or at least my passport or the padlock on my door. But I do wonder if we can suspend or I can suspend that antipathy for a moment, and wonder if we need at least a thin theory of a more substantive public interest that is not merely defined by opposition to private interest. And my concern is that private interest is very often justified in the name of public interest. I'm thinking of things like the Kelo versus New London case in the United States, of the claim of appropriation, expropriation of public land, of private land, rather, of houses, supposedly for the public good, but the public good turned out to be, back then they were not the heroes that they are today, but it turned out to be a Pfizer plant that eventually never got built. And the public interest that was cited was the Pfizer plant will pay higher taxes and therefore redound in the public interest. Or for that matter, all talk about trade barriers, many of which benefit insiders at the expense of outsiders, or both sides of the Uber debate. Now, the public interest is invoked very often to counter efforts to restrain concentrations of power. And there's one part where Bagg mentions that the economists have a general consensus in favor of anti-monopolistic measures. And I'm not sure that the consensus is as secure as Bagg claims. I'm thinking specifically of the turn in antitrust legislation around the time of Robert Bork, which moved from having antitrust legislation be a matter of resisting concentration of power and turned it into a protection of consumer value. And that's ultimately what many economists have been saying against the attempts to regulate, say, Amazon, saying Amazon is an extreme concentration of power, but as long as their prices remain competitive, there's absolutely nothing to worry about. Here, the question is, what is the public interest? Is the public interest just the aggregate of prices that consumers would have to pay, or is the public interest the concentration of power itself? I obviously think that Bagg thinks it's the latter, but that requires a thicker conception of the public interest than merely the claim that it is not the private interest. Because very often the public interest and the private interest can go together. What's good for General Motors is good for America, can be framed in other ways and is not always obviously false. Now, one solution is to say that non-capture is the public interest, but that seems somewhat tautological or empty. I think there may be a way to escape that. I think it might be interesting to say non-capture is that is preserving the conditions of non-capture is in fact the public interest. Also, attempts to avoid capture may simply shift the mechanisms of capture to a different level. And here I'm thinking of 19th century progressive successes that I think are normatively in line with what Bagg is proposing, of facilitating referenda in, say, the constitutions of the Western states, or doing away with the machine politics of Tammany Hall. But when you do away with the machine politics of Tammany Hall and start facilitating referenda and end up with the current primary system, you still have capture. And you have capture that has even more perverse effects in terms of polarization, nationalization of elections. Tammany Hall may be the closest thing that we can get to a functional materialist constitutionalism, where particular interests from different neighborhoods, from different sectors of the economy and of society can meet in those back rooms filled with cigar smoke, but not have all of their claims arbitrated exclusively by the leaders of the Democratic Congressional Caucus, for instance, which is what seems to have become the case. All right. So on Beaumont's claim, just a few points. The question, I think it's a question that Beaumont struggles with as well, although she provided a definition at the end of popular constitutionalism as a mode of politics. I think it's interesting that the definition is also negative in an important way, because the popular constitutionalism is the constitutional actions that do not come from the elite. And especially if we don't reduce it to populism, it ends up being something like a you know it when you see it kind of concept that escapes some analytical clarity because of all of its diversity, but also by defining it in the negative, we can see that that the focus is really on upsetting the control, the monopoly of constitutional interpretation and creation that the elites have. Is popular constitutionalism driven mainly by social movements as opposed to elite bargaining? Well, the problem is that these may not be mutually exclusive. There may, in many cases, be elites that ride on popular movements, that encourage certain popular movements. We can see this, for example, in the kind of AstroTurf popular campaigns that are funded from the center and very often don't actually have a deep popular root, or if they do have a deep popular root, it is not the root that is being articulated as constitutional interpretation. It may be racial resentment or something along these lines. I think in many ways, we can frame popular constitutionalism as a question of agenda setting a bit, and then have those institutions of popular constitutionalism, thinking of another class that I teach sometimes, as akin to a shareholder initiative in a corporate meeting, or akin to the structures in which you lower the threshold of participation. But I think that there may also be some criterion of success, that is, of not just being able to set the agenda, but actually being able to pass that shareholder amendment, which very often does not pass in corporate shareholder meetings. There's a triad of levels that I thought could be interesting in terms of framing the question of popular constitutionalism. One of them is whether it's about constitutional interpretation. And I love the fact that Robert Cover is in there in footnote 9. Robert Cover has this wonderful article that I teach every day, every time I teach my Foundations of Law course to first-year law students. Nomos, a narrative, where he says that a nomos, a normative world, is created in connection to a narrative, and the narrative is the site of these interpretive commitments that people have to the normative world. That it's not just the text. The text needs to be accompanied by an interpretation, and the interpretation is given by a different narrative context. That he mentions the Mennonites, for example, and their experience of oppression, their identification with previous generations of martyrs, and dubs this a kind of insular autonomy. But he also talks in the context of anti-slavery movements of redemptive constitutionalism, which is very often the kind of popular constitutionalism that I think gets most noticed. Redemptive constitutionalism as a constitutionalism along the lines, for instance, of Lincoln's arguments about the Declaration of Independence as a constitutional document that redeemed the Three-Fifths Compromise. Again, the other text, apart from Cover's Nomos, a narrative, that I always show my first-year law students is the second greatest text in political philosophy in the 20th century, after, of course, John Rawls's Theory of Justice, The Man Who Shot Liberty Valance. The Man Who Shot Liberty Valance has this wonderful scene, it's my favorite scene in the entire film, where Rand Stoddard, the lawyer, coming from literally with a bag made of carpet full of law books, has come to a Western town, has decided to establish a literacy program, has a little school that he opens up. And many people come in, including John Wayne's, Tom Donovan's, the name of the character, John Wayne's manservant, a former slave by the name of Pompey. And there's a scene where Jimmy Stewart, Rand Stoddard's character, asks Pompey to recite the first words to the Constitution. And Pompey stands up and says, Mr. Thomas Jefferson wrote it. And it says, we hold these truths to be self-evident, that all men are created equal. And if you notice, behind Jimmy Stewart's character is a picture of George Washington, but behind Pompey's character is a picture of Abraham Lincoln. So this act of constitutional interpretation is the kind of thing that Cover is talking about, but I think it's also an act of popular constitutionalism. So popular constitutionalism reclaims the executive authority of not the law of nature, but the constitutional law in a certain way, which, if we go to Locke, actually includes judicial or interpretive authority. But it doesn't negate constitutional law. It's not necessarily a revolutionary act that denies the Constitution. In some cases of the anti-slavery movement that Cover talks about, there is this condemnation of the Constitution, but ultimately it's mostly because of pre-constitutional principles like those of the Declaration. Finally, if we order the institutions of modern representative democracies in order of elitism, we can start perhaps with the most elitist, the courts, the most indirectly appointed, the smallest, the ones who very often, not always in every country, but very often serve for life or until a certain age, as long as they are not impeached. Then we move to an upper house of some sort, then to a lower house. The president is oddly situated because it is the most concentrated power, but at the same time, it's very often has the broadest base in terms of election, so they can claim something like a broad representation. So if we look at these different places, these different institutions, we can ask, if opposition to the most elitist institution, to judicial power, which is one of the persistent stereotypes, but a stereotype that we can perhaps extend in a less stereotypical way, as comprising not just the courts, not just the judiciary, but those who share their views, the people who would clerk for courts, the people who would talk to courts, who would meet them at cocktail parties in Washington, for instance. Opposition to that kind of class would ordinarily need to substitute some other kind of institution or abandon representation altogether. That is, we could have a popular constitutionalism that acts directly in the form of an Athenian assembly and interpret the Constitution directly. But very often, what popular constitutionalism does is to shift the focus to some other institution, some other movement. So which institution is going to be substituted? And to wrap up, I think one possibility is to suggest that the answer is none, that one of the answers of popular constitutionalism is that all institutions, as soon as they become institutionalized, are captured by elites. Even local institutions can be captured by local elites. And in that case, even a kind of stable popular assembly, that is a permanent feature of popular assemblies who speak on regularly on given proposals, Iris Marion Young herself has pointed out, is subject to capture by those who speak best at those assemblies. The lawyers are still going to be in charge. One answer maybe is that there's an ephemeral character to popular constitutionalism, that it is something that can rise up in a movement but cannot actually be institutionalized in a permanent way. Again, turning to The Man Who Shot Liberty Valance, one of the last lines of Hattie, Ransdotter's wife in the film, is looking out at the town of Shinbone that has been transformed into a prosperous town. Look at it. It was once a wilderness. Now it's a garden. And with great melancholy, she says, aren't you proud? There's the popular element that has been effectively extinguished by its institutionalization. So maybe that's where popular institutionalism ends up, in an ephemeral moment that necessarily fades away. Thanks, Jacob, for keeping the time. So I'll give a few minutes if Bagg or Beaumont want to reply to each other or to what I said, and then we will open it up for questions.
Yeah. Would you mind if I go ahead?
Yeah.
Sure. So I'll try to keep it brief because I do want to hear the questions. I'll just try to say, well, first, thanks for that really, great set of questions. I'm going to try to address a few of them just in order. So do we need a theory, a thin theory of the substantive public interest? So sort of no, but sort of yes. Sort of no, because on one hand, we can identify deviations, I think, more confidently, and we can agree about them more so than we can identify public interest itself. So we don't always need to know exactly what public interest is in order to know what is not public interest. And second, we can, even if we can't do that, we can still often identify institutions that are going to prevent capture, even if we don't agree on what the public interest actually is. So we can identify deviations from the ideal, and we can identify institutions that will prevent people from turning away from public interest, even if we don't sort of have exact conception of what public interest is. But ultimately, yes, we do need a theory of the public interest in order to apply it in particular circumstances, right? And of course, private interests are always going to masquerade as public interest. All the examples you give are good of cases, Chile versus New London, and Uber, the antitrust ideas, right? And of course, I have my own views on what the real public interest is in these cases. But what I'm trying to do in the book, and especially in this chapter, is not to argue for any particular view on at least some of those questions, but instead to kind of lay out the sort of framework within which I think it's going to be most productive to argue about those questions, right? Rather than, so then it's a further step to say, okay, well, in Chile versus New London, here's how we should think about it. Here's how I should think about, the particulars of that case. On the interest question, I do take a side there in the chapter. Robert Bork is wrong. The progressives are right. But it's not because, non-capture just is the public interest. It's because concentrated corporate power poses many other threats to the public interest, right? And many of them will be direct, so they undermine worker protections. They maybe undermine a kind of long-term dynamic efficiency, even if they have a kind of short-term price reduction effect in the short term, right? But often the argument is also going to be indirect, right? The idea is that whatever the public interest is, it's just not a good idea for anybody to have that much concentrated power, because anybody with that much power is going to have the capacity and the incentive to turn public power to their interest. So we don't need to know exactly what the public interest is in order to say, look, this is a threat to the public interest. And so that, that's why the progressive conception of interest is better than the sort of Robert Bork conception. I think I'll stop there. Yeah, thanks.
Elizabeth, do you want to say something?
Well, we'll have to have a chat later,
Sure.
a virtual drink. You gave me so much to think about. Thank you very much. And it made me think like, gosh, I should just take you on as a co-author. You have so many good ideas. But I think because I have already abused the clock a little bit accidentally, I didn't realize I was going over my time. I'd love to just get some other questions in here rather than trying to respond to you directly. Thank you.
Great. All right, so I'll just open it up for questions, and we can always do what we've done in the previous panels, and it's to just stick around on open mic after the panel is over. So Kevin.
Thanks so much. This has been a wonderful panel. It's a great couple of papers. But I wanted to basically ask a question of Sam. And apologies for how this is going to sound, but I continue to struggle to see the attraction of the fundamental goal here. It still seems like, in the title of the book, sounds to still be that the aim is the dispersion of power. But I think we've talked about this before. Sometimes concentrated power is dangerous, sure, but sometimes it's necessary to save lives. Sometimes it's necessary to advance justice. And it seems to me that the account that you're putting forward just does not respond to that consideration. So, for instance, how do you get the solution of collective action problems when power is very thoroughly dispersed? How do you get coordination on solutions? How, for instance, do you get universal social insurance programs enacted when there are so many different ways to mobilize opposition to them? A big problem, I think, that's lurking in the background here is that the ways of the various ways that power will be dispersed, in order to actually make use of those, they're going to be very effortful. It's very hard to organize collective action, right? And so if there's lots of different capillary ways for power to sort of be organized and be mobilized, that seems to me to likely, it's going to empower people who know how to organize power. It's going to advantage the people who are already powerful, who are already well provisioned, not just financially, but people who, and this is, I think, Victor's point about speaking, who's going to dominate, Young's point about who's going to dominate in an assembly, people who have civic skills, people who are politically interested, people who have the embodied knowledge of how to participate. These are not necessarily all rich people, but they are more likely to be. And so these people seem like they're going to be the best position to make use of these new avenues for contesting power, to mobilize and organize opposition through all of these different ways that you want to say. Sorry. So this is just basically Schatzsnyder's critique of pluralism, right? In light of the ways that the advantaged are always better able to organize collective action, why wouldn't we expect the heavenly chorus of a dispersed democracy to sing with an upper class accent? Please explain. Thanks.
Should I go ahead and answer, or are we going to do other questions?
You can go ahead and answer. If things start getting too crowded near the end, I'll just take a couple of questions.
Okay. Great. Yeah, so I think part of this may have to do with the sort of fact that I left out, some of the background and motivation. So the way that I see democracy is kind of an adverbial ideal. So assume that concentrated power is good in some cases. We need it to do stuff, and regardless, concentrated power of states exists. Like, so even if we didn't think it was doing good things, like we just take that for granted. But I mean, certainly concentrated power does. That's like point one. Yeah, concentrated power does stuff. That's great. We needed to do that. Democracy is not the only valuable thing. What democracy is how we do that. How we understand, like, and go about regulating that kind of concentrated power. And one way of thinking about what we need to do in order to regulate that concentrated power is to exert this kind of collective self-rule over it. And that takes many forms. And I think it leads to many good ideas. But I think ultimately, it's better to see what we're doing when we're sort of trying to regulate this concentrated power that we absolutely need, is to see it in the terms of resisting capture. And ultimately, what we want to do is to disperse social and economic power. And so the first part is like, yes, concentrated power is good for many things that are just not democracy. And then the second thing is that, yeah, some forms of concentrated power are necessary for democracy. And this is what the whole idea of countervailing power is about. Like, that's the kind of thing we need to build strong unions and strong community organizations and strong organizations of people who are at the bottom, right? And that is the only way to contest. I mean, because I agree with everything you say about, yeah, especially deliberative institutions, right? That's kind of my point. Like, those things are going to be more susceptible to manipulation by the people who are already advantaged, right? So the point is to build institutions and systems that are going to allow people at the bottom actually to exert power in their interests, which I think sort of more formally neutral political institutions cannot do, right? So that's why it's more about the dispersion of social and economic power rather than a kind of collective political self-rule.
Great. Angelo.
Hi, thank you. So I just want to thank all the speakers. The past few days of listening, observing have been so incredibly informative to an undergraduate like me. My question relates to Professor Beaumont's presentation and the preceding panel of graduate students where Vertica explained her paper on populism. It also kind of relates to the work of Professor Jacob Levy's Rationalism, Pluralism, and Freedom, where he develops a kind of non-synthesizable contradiction in thinking on the right of association and group membership / identity between pluralists who believe that individuals have the right to associate without state intervention based on the common law doctrine of valenti non fit injuria, and rationalists who believe state intervention is necessary to ensure individual rights from group tyranny. My question is where populism, especially right-wing populism, falls in the almost dialectical relationship between rationalism and pluralism. Does it fall into either one at all? Basically, what is populism's view of the right to associate?
Thank you, Angelo. Really interesting question. I don't have a terrifically well-developed answer to you, but I guess if I had to go off the cuff, it seems that right-wing populism is, pretty clearly generally anti-pluralist, suspicious of pluralism, and so I just sort of pin them more kind of in that vein. It doesn't mean that maybe there isn't a case to be made that there's a kind of rationality to their activities, and their clearly they have a strategy in mind. So I don't know. I guess maybe I would turn it back to others, since I don't, I haven't thought about it in these terms before, and so it's kind of stuck a little bit in formulating a helpful response.
All right. So, Agnes.
Hi everybody. Thank you for this wonderful panel, and thank you, Jacob and Victor, for organizing it. And I have two kind of related questions, or maybe not related questions for Elizabeth. But first of all, I just want to say I really enjoy this paper. I think it's by far the most honest, most articulate account of the promise and peril of popular constitutionalism I've read. So I learned a lot from the examples too. So, but then it's honest, it's articulate, but I'm not sure whether this expensive conception of popular constitutionalism is the most useful to pick out what exactly is so popular or what exactly is so constitutional about these distinctive mode of politics that concern you and others. So to remind the audience about your particular definition of this distinctive mode of politics, you state that it's a mode through which members of the political community assert their constitutional views and claims into constitutional debates and politics. And this mode of politics includes the forms of ideas, discourse, and politics through which civic actors invoke principle of fundamental law and make constitutional claims and assert a role in shaping the meaning of the Constitution. So this sounds fine, but as you unpack these different elements or these different elements of this definition in the rest of the paper through different historical examples, I realized that first of all, popular constitutionalism as a mode of politics can take place at multiple levels, as you say, indoors and outdoors. So it doesn't confine itself to the civil society. It can take place in electoral politics, can take place in judiciary activism and elsewhere. So it can take place almost anywhere. And insofar as the mode of politics is concerned, and as you explained, it can be contentious. So it can be radical, sometimes extremist, sometimes violent, but it can also take deliberative modes and nonviolent peaceful modes. Okay, and then insofar as the content, the ideas that the civic or less civic actors invoke to justify their claims and power to rule, or at least to set a gender, as Victor suggested, these ideas and discourse can be liberal or illiberal or even other ideologies out there. So if we understand popular constitution this way, it seems to encompass almost everything that happens under politics or democratic politics. So if that's the case, so how useful is this idea? So I guess your answer maybe say yes. That's why we need to look at the specific elements of popular constitutionalism. That's okay, but then might it take away some analytic power and also the normative power of the grassroots activists when they try to invoke the normative power of we the people, or this a form of united people to justify their claim. So that's question number one. So how useful is this? Question number two is a smaller question.
If I might, because we have a couple of other people on the queue, if you don't mind getting back on the queue at the end and then asking question number two then, okay?
Well, I'll try to give a very brief response, and of course, Victor raised the same issue: is that this is an anti-parsimonious. This is about a broad umbrella of popular constitutionalism as you can get, and yeah, as you said, I think that this is honest, but it does, of course, obviously open me up to the criticism that once you have such a broad definition, it seems like everything becomes popular constitutionalism. I don't think that's the case, but I do think this, and this goes back to a point that I made, and also one that Vertica had made in the prior panel, that once you have a form of government that purports to be a constitutional democracy, this form of politics is constantly being encouraged. And then once it's encouraged and used successfully by any one group, it is, kind of used on the other side and in other ways, and groups, and sort of a lot of the social movement literature suggests ways that repertoires develop and are shared and stretched and so on. And so I guess I would say I fully recognize that having a much narrower conception would bring more analytical clarity. It would really kind of make for a more pointed capacity to, kind of exclude maybe forms of politics that we disagree with. So, I gave the example of people who want to save popular constitutionalism from radical populism by saying popular constitutionalism is only the kind of the uses that are compatible with liberal democracy. And I'd say I'm very sympathetic with that. There's part of me that does want to save it, but I also think that is a dangerous view, that I think this is a mode of politics that has been used incredibly successfully by those on the political right and by those who are illiberal. And that in some ways, particularly in the US context, it's easier for them to make constitutional arguments because they can always claim to be hearkening back to a constitutional past that was exclusionary and that was repressive and that did prevent many groups from having the rights that they are claiming. So I do think it's important to have a broad definition, even if one loses analytical clarity and kind of, is always open to the charge of non-parsimoniousness. But thank you for the question. It's a really good point.
Thank you. So Jeff?
Hello. Yeah, I'll just echo what everyone else said. This is a great panel. I have two questions, but I guess I'll save the second for after. So I guess my first would be to Elizabeth as well. So I just have a general question about the relationship between popular constitutionalism and constitutional democracy generally. So is it inevitable? Does popular constitutionalism kind of occur in any constitutional democracy? Or is it something that is encouraged or managed by the rules or institutions of a particular constitutional democracy? So, for instance, is the U.S. the kind of classic example to talk about this? Partially because it's especially prevalent because of the nature of this country's constitution. It's vague, it's abstract, it's very hard to change. So that would mean that in other countries there'd be less of what you're referring to as popular constitutionalism, if the normal elite channels of legislative change are more easy to use to amend the document. So I just want to ask if you think this is something that just goes hand in hand with any constitutional democracy, or if it's something that we should expect to arise from particular constitutions.
Yeah, great question, Jeff. I think I do think that it's endemic to constitutional democracy, but I also do think that you would see variation in the extent to which, kind of it is practiced or used in different countries. And I do think it's one of the reasons why the US case is kind of interesting, that in a sense, because the practice of popular constitutionalism helped to shape, kind of the constitutional institutions and structure itself, it gives a kind of either path dependence or kind of institutional, anchor to future groups in ways that other constitutions may not. As to sort of how we would parse that out, I think this is where having people, with deep knowledge of other constitutions, which I wish, my knowledge of constitutionalism outside the US is woefully thin, but this is where I think some great comparativists can come in and say, where do we see it most often? When does it start occurring in other countries? Does it start occurring on the cusp of transitioning toward a constitutional democracy? Does it occur before that point? Does it start to happen more often once a country claims to be a constitutional democracy? Because I do think that those, kind of those questions, as well as the question of what latitude is given to civic groups for protection for rights to assembly, association, speech, and so on, is clearly going to some extent limit or enable groups from forming and being able to develop forms of popular constitutionalism. So I think all of those are really important questions, and I would love to have like a smart answer, but I think that my response is like more. I hope to create a cottage industry of many people studying this, because I think the more we understand it, the more we'll know how, when, and where it's helpful and useful, how to combat the forms of it that kind of seem to always also be going alongside the more beneficial uses.
Vertica.
Yes, so of course, great panel. And I especially liked it because it was so overlapping with the previous panel. as well. So I have questions for both Sam and Professor Beaumont, but I guess in the interest of time, I'll have to stick to one, and maybe I'll get a chance to say my second question later. So for Sam, it's too bad that Mila is not here, because like I think one of the things which she makes point is like what happens with this excessive view of like, let's say, dispersing power, or like an excessive commitment to progressive politics, is that we get this kind of wokeness in which we don't realize that like I think she's termed as like POC fetishization. I think like maybe you can get my point. It's basically that we don't criticize, let's say, some members of the marginalized group if they behave in exactly the same ways as privileged groups would. And this happened at the moment when Kamala Harris was, announced as vice president. So I think basically I'm pretty much like hinting towards the fact that like, are you kind of making the argument that a dispersion of power is just good procedurally, or it would inevitably lead to better progressive outcomes? Because if it's the first one, then that's like an outcome just of procedure, is that power should not be concentrated, and regardless of what outcome it leads to, like we must disperse power. And that's a very powerful argument. The second one could be great too, that no, dispersion of power actually leads to better outcomes as well. But if it's the second one, how would you defend that?
So that's a very tough question. Well, so here's what I'll say to start. I think I'm trying to really trouble this distinction between procedure and substance. And so what I want to do is say, I mean, in a sense, well, so on one hand, to the extent that it's procedural, that it's about procedures, our procedures are valuable because of the outcomes they produce, right? So that's one thing. And the second thing is, yeah, it is adverbial in the sense that I sort of said in my response to Kevin, in that we're talking about how to exercise this concentrated power, but in any sort of sane sense of the word, in terms of like, the way that we usually interpret the words procedure and substance, it's not just procedural, because it's talking about all these substantive policies that need to be implemented in order to do this adverbial thing better. So I think, yeah, I mean, it's a tough question I don't want to put on either side of the line for those reasons. But yeah, thanks for the question.
All right, so we are at time, or 1 minute short of time. What I'm going to do is I'm going to stop the formal panel right here, but keep the cameras open as we've done before, so that people can keep asking questions. And I think Mariah gets her own panel in the next session, so she has that opportunity there. So thank you very much to both of the panelists today. It was a wonderful synergy that hardly ever happens, especially with panels that are put together in such a broad topic. So thank you very much.